So this was Ginger Corporate Clock. Another video. Same one that we have not finished off on, and I'm behind schedule on this. I apologize, I'm stretching this out too far. If you guys are interested, you go ahead and keep checking out the videos. Number one, it's already conflict of interest anyway. That guy in there from the bar, the district attorney from the bar. So there's 2 against 1. It's conflict of interest. When the officer shows up, he's on the clock. That's 3 for the state. Conflict of interest. This is how they get us, y'all. Conflict of interest, conflict of interest. And they keep on saying they're not allowed to have conflict of interest, but yet they do it every single day, 100 times a day.
Objection. I believe if you believe you have jurisdiction to actually conduct a hearing, I want to know what evidence you're basing that on and that you got from Ms. Killam. Do you believe that you have jurisdiction to conduct a hearing?
Alright, I guess I should go back to the hearing notice and the statutory authority.
So he's going to go back and explain that again.
In the hearing because we did not have you on the record at the time. Mr. Freeman has been ordered to appear and show cause why his driver license or operating privileges should not be revoked or denied. To review receipt of information submitted from Keene Police Department that could be hazardous to public safety. The person who shall be subject to such an order shall include but not be limited to one whom, and I will narrow it down. Number 2, a law enforcement officer has reported for misconduct. That is appropriate based on RSA 263.56, 263.59. Administrative Rule SAFC 20403, Administrative Rule SAFC 20413. That's my authority.
Okay, now the question is, has Ms. Killam provided you with any evidence to prove that the Constitution, laws, and the state of New Hampshire actually apply to Ian, to prove that you have jurisdiction or to establish your jurisdiction? What has she given you evidence-wise to prove that the codes apply to Ian? Again, because I do have an objection to the appearance of the police officer. I don't believe that Ms. Killam has any evidence that he has any personal first-hand knowledge of the Constitution, laws, and the state of New Hampshire apply to Ian.
Okay, so a couple of problems that are wrong there. Number 1, you cannot prevent the witness from testifying where the witness is there to establish the issue of jurisdiction. So you have raised the issue of jurisdiction. Obviously, the state's attorney or the prosecutor was not there at the time that the traffic stop occurred. The only person with first-hand knowledge of that would be the police officer. So you have raised this issue and opened the door to this police officer testifying. So you cannot simultaneously raise the issue of jurisdiction and then object to the state's modality of proving the jurisdiction. Secondly, the police officer is a fact witness. So he is a witness as to what happened, what was said, and that's it, right? And based on what happened and what was said, then the judicial or the quasi-judicial official can make the determination of whether or not jurisdiction has been established and whether or not the license should be suspended according to the administrative rules, right? Well, here, what Mr. Stevens is asking this police officer to do and saying that he can't testify, he's asking the police officer to testify that this court has constitutional authority over Mr. Freeman. This officer cannot testify to that because that's a legal conclusion. Fact witnesses, and basically no witnesses, can make legal conclusions. Only the judge or the finder of fact or the administrative hearing official makes the actual conclusions on the administrative rule or the law, right? So they're the ones that make those types of conclusions. So you cannot say the officer can't testify because I know for sure he won't be able to testify and say that the laws apply to Mr. Freeman because first of all, it's a faulty premise because this officer could never testify to that. But secondarily, because you're raising this issue, you've opened the door to this officer being able to testify about where he made the traffic stop, when he made the traffic stop, and who he made the traffic stop on. And so based on all of those things, Mr. Stevens' arguments are inadequate.
He doesn't need that knowledge, sir.
No, he doesn't.
He doesn't need he's allowed to speculate in this hearing?
No, and that's not what the administrative hearing official is saying. It's not that he has the ability to speculate. It's that he doesn't need to test. Mr. Stevens is moving the goalposts. The goalpost is simply that this officer testifies to what he heard and what he saw and what happened, right? What Mr. Stevens is trying to do is impose this additional hurdle that does not exist within the law or the administrative law, that this officer also has to establish that the constitutional laws apply to Mr. Freeman. The state constitution does not need to apply to Mr. Freeman because this is not a constitutionally convened court. And also the determination of whether or not the court ultimately has jurisdiction over Mr. Freeman, which is what Mr. Stevens is really arguing, is made by this administrative official, not by the police officer. So he's misconstruing the words of the administrative hearing official.
I was going to wait a little bit longer. But sit and think about this for a minute. The officer acted as attorney saying, hey, you did break a law. And he's acting as a judge. I'm going to sentence you. But I'm going to give you an upper court date. So he gave the ticket for a higher up court. But in fact, when he filled out that ticket, he made it lawful, or what they call lawful. He made a legal determined. He acted as an attorney to be able to fill that ticket out that he broke the law. And the correct way the officer is supposed to be doing this is actually getting as much information as he can, send it to the prosecutor or the DA. They decide whether they're going to go ahead and go through with it. And then the judge signs off and say, hey, you need to appear for court at X amount of date. The officer is not even legally allowed or lawfully allowed to set your court date. Period. That's out of his jurisdiction, believe it or not. I know some people is going to disagree with me on it, but legally and lawfully, he's just a middleman. And he cannot set any court dates. And remember what I said. Check out Minority Report with Tom Cruise in it.
Going to testify about his knowledge of facts as they apply to his knowledge of law in the state of New Hampshire.
But one of the issues he has to prove, one of the elements, is that he has to prove that the Constitution laws of the state actually apply to Ian. And if he doesn't have personal first-hand knowledge,
Let me finish, and I have not accepted that opinion at this point,
So Mr. Stevens is not citing, and here when you want to make these type of legal arguments, quasi-legal arguments, pseudo-legal arguments, when you want to make these types of arguments that clearly the arbiter of the facts and the law and the one who determines what's going to happen is not agreeing with you, you have to provide case and statute cites to support your theories. You have these theories that this officer is supposed to testify that the constitutional laws of the state of New Hampshire applies to Mr. Freeman, right? Like he just keeps repeating that sentence over and over again. But there's no legal authority for Mr. Freeman to say that. So he's just wrong about the law, and he has nothing to back up what he's saying.
I agree with her. I know, it's shocking, right? However, Stephen does have lawful authority. He's staying out of legalese and he's staying in lawful. Two different things. Now, lawyers and judges may say something totally different, but if they was the same, they would be called the same, right? That's the reason why legalese is separate from lawful. Two different definitions. Stevens is staying on the lawful side, and they're staying on the legal side.
So now
Well,
the
what
question.
I'm asking is, does Ms. Killam have...
Oh, just one other stylistic point that I'd like to point out that maybe because Mr. Stevens is not an attorney, he doesn't understand. When you're yelling at the person that's going to be making the ultimate determination, like let me finish, and I'm going to speak over you, and I'm going to stop you from talking, and I'm going to force my way through. What you're doing is you're hurting your client.
Mr. Freeman,
Yep.
either he is representing you and he will ask the questions, or you are representing yourself. You need to tell me right now.
If Mark would like to continue on that, we can have Mark continue.
And I would just like to say that the hearing official, the hearing examiner, is serving two purposes here. Number one, Mr. Freeman had spoken up and tried to explain Mr. Stevens' arguments to the hearing examiner, and that is not allowed under any, type of hearing, because you need to have one issue, one voice. Even if you had both of them being the representative on this issue of jurisdiction, it really should just be one person making the arguments. And number two, Mr. Stevens is not doing a good job. He's making arguments that have no basis in law or facts, that are not supported by the authority given to this administrative body. So Mr. Freeman could at this point in time say, you know what, Your Honor, I'm going to take over from here and I'm going to represent himself. And he might have had a better result had he represented himself. But so the hearing examiner was giving Mr. Freeman an out, but Mr. Freeman didn't take it.
Okay, and that means that he asks the questions and you do not. He can put you on to testify at some point if that's what you desire. But I'm not going to have him ask questions and you ask questions and him ask questions. It's not the way we're conducting this hearing.
As long as he's allowed to ask questions, I will ask him questions.
And he's going to be allowed to ask questions as long as he's not disrupting the flow of the hearing. If I determine he is, he will not be allowed to talk anymore. And you can take over.
Right. Okay.
Officer, raise your right hand, please.
What objection? My objection has been heard and determined. Does Ms.
So the judge has already ruled on this objection long ago, and he said that he disagrees with him, and he's moving on, and he's swearing the witness. What Mr. Stevens is doing is just continuing to try to disrupt the proceedings. He's not making any different arguments. He's not raising any case law, any statutory authority. He's just repeating the same argument over and over and over again. And in a real court, that would get you in a lot of trouble, but here he's in this hearing examiner's office, so he gets a little bit more leeway.
Killam have any evidence to show that the witness has personal knowledge?
Objection, sir, and we are going forward with evidence. And if you
So let me just a point of clarification. You're going to allow the witness to testify.
are going to keep beating this dead horse, then you will be disconnected.
It's dead. It's very dead.
I just need to understand your decision. You're allowing the witness to testify without any showing his personal knowledge of the matters.
Who doesn't have personal knowledge of the matter? The officer, I believe.
And see, that's a different question than what Mr. Stevens was raising. So, for example, Mr. Stevens was previously saying that this officer can't testify that the constitutional laws of the state of New Hampshire apply to Mr. Freeman in particular, right? And you're saying, and even though he can't testify to that, you're still going to allow him to testify. That question is inaccurate. It's based on an inaccurate premise. And I think Mr. Stevens is starting to realize that. So now he switched his question to this officer has no factual basis to testify. Now, if that is your argument, that's a completely different argument. But unfortunately, the answer to that is to allow this witness to testify to the hearing examiner. Now, if it was a jury, that would be a totally different question. I can address that at a later time. But in this type of hearing, you allow them to testify to this hearings examiner. And then the hearings examiner can hear from you any evidence that you have to show that this officer has no personal knowledge. The officer wasn't there. It was another officer. This officer is mistaken. This was another officer's case. And he's just stepping up and speaking out for this officer who he's not. And here's some evidence that this is not the right person. That's a different question than what he raised before. And unfortunately, the only way to get to the answer of that question that he's raising is to have the witness testify.
does, and I don't know that until he testifies, do I?
Not necessarily. Ms. Killam has filed a complaint and is basing everything on this witness's testimony, and she is responsible as the prosecutor to be able to confirm that the witness does have personal first-hand knowledge of the evidence before she puts him on the stand and calls him as a witness.
I agree.
So even if, say, the prosecutor was completely unscrupulous and was and had never vetted her witness and never spoken to him and doesn't know if this is actually the person that has knowledge of the facts of the case, she puts this witness up there. Now we're in front of the hearing examiner. The hearing examiner will hear the evidence from the witness to determine whether or not the witness has firsthand knowledge of the case and whether or not they find that testimony to be credible despite what it is that the defense says in the case. So this objection, once again, bears out the necessity for the officer to testify.
She's prosecuting the case. I need to make the determination whether I think his testimony is reliable, and that's what the rules say.
That's it, yeah.
Rule 602 says that no witness may testify to a matter unless there's evidence showing that they have personal knowledge, and that's all I'm at.
Rule 602 is federal rules of evidence. Federal rules of evidence, which again, the federal rules of evidence do not apply to this because this is not a constitutionally formed federal court. This is a state executive branch formed administrative court. That's what this is.
Asking is for Ms. Killam to be able to confirm that the witness has...
What rule did you just refer to?
602.
Rule 602.
What rule is that? I don't have Rule 602.
It's the federal rule.
Rule 602 is in the rules of evidence that give some of the qualifications for the witness.
Federal rules of evidence, sir?
I believe that New Hampshire has the equivalent to the federal rule.
No. First of all, not every state has the equivalent to the federal rules of evidence. They have if you're going to you cite federal rules of evidence when you are in federal court. They're actual federal courts, and you cite the federal rules of evidence. When you are in a court that falls under the judicial branch of government, then you use the state rules of evidence. If you are in an administrative branch of government hearing court, an administrative hearing court, like the Bureau of Hearings here, you use their rules of evidence. They promulgate their own rules of evidence, which I've already read to you, right, which says that they allow in hearsay and that they are on a preponderance of the evidence, which is the lowest standard.
Agreed.
Proceeding, we have administrative rules. That's what governs this hearing.
Simple.
Okay, so let me just understand correctly that a witness may testify without showing from the prosecutor that they have personal first-hand knowledge.
And again, what you're doing here is you are, and as they said in their rules, they don't provide you, the party, with legal advice. You provide the legal arguments, and then the hearing examiner makes the legal determination or the determination under the administrative rules. But it is never advisable or correct for the advocate to ask the judge or the examiner for advice. Then you don't know what you're doing.
He is a witness who has...
Alright, I'm going to end it there and I guess make another video. I talked way too much and I apologize. We'll try another video, finish this out. This is for y'all just to kind of brush through and see what's going on.